Actually, Warren, you were convicted by a jury of being the owner of a dog which, while dangerously out of control, caused injury, resulting in the death of Esther Martin. The jury also convicted you of an offence of having an article with a blade or point. Today, you've pleaded guilty to 2 additional offences of possession of a prohibited dog. Esther Martin was 68. She was a much-loved mother and grandmother. She has been described as kind, fun-loving, funny, unique, and one in a million. The court has heard deeply moving statements from her daughters, Sonia Martin and Kelly Fretwell, and her son, Paul Martin. Those statements vividly explain the impact your offending and her death and the manner of her death have had on her children and on all who loved her. No sentence can reduce their loss or take away their pain or reflect the infinite value of her life. You are 41. You've been convicted of 15 previous offences. Those include offences of robbery and assault and breaching a non-molestation order. The most recent convictions before the matters that are now before the court were in 2015 for 2 counts of assault occasioning actual bodily harm and affray, putting you in breach of a conditional discharge. On that occasion, you were sentenced to a total of 56 weeks imprisonment. In February 2025, you were the owner of an adult male XL bully dog. You also possessed an adult female XL bully dog. They were each large and powerful dogs, even by the standards of XL bully dogs, weighing 47 and 39 kilograms. They had a litter of puppies. You kept 8 of the puppies with the adult dogs in your house. You were aware that a law was coming in to ban XL bully dogs. That law came into force on the 1st of February 2024. You knew that the breed was banned from that date, but you did not take any steps to comply with the law and the requirements imposed on those who had XL bully dogs. None of the dogs were neutered. None were muzzled. You did not have any certificates of exemption. More than that, you did not properly look after the dogs. They were confined in too small a space, and you had not walked them in the 4 weeks prior to Esther Martin's death. That greatly increased the risk of aggressive behaviour from them. When you were challenged about the dogs, as you were, you said you did not care what anyone said, that you did not give a of the rules. Esther Martin was so concerned about the dogs that she was thinking of secretly reporting them. You knew how even the puppies were capable of causing injury. You'd referred to injuries that you had sustained from them. And you certainly knew how strong and potentially dangerous the adult dogs were. You knew that Esther Martin could not hope to control them. She was just 5'3", with a history of medical complaints, including a hip replacement, osteoarthritis, and diabetes. She was not stable on her feet. On the 3rd of February 2024, you arranged for Esther Martin to look after a pre-teenage child at your home while you went to London to record a music video and to meet a person who you described as your lady friend. Whilst you were away, it appears that the puppies may have started fighting. It's possible that an attempt was made to separate them, and whether in the course of that or otherwise, Esther Martin fell to the ground. The two adult dogs responded by attacking her. She was mauled to death. She sustained dozens of dog bites to her back, her chest, her abdomen, her head, and all 4 limbs. She suffered a catastrophic bleed, which resulted in her death. The dogs were so aggressive that police officers were initially unable to enter the property. The adult dogs had to be destroyed because they posed a continuing further risk to life. Esther Martin was the first person to be killed by an XL bully dog after the new law came into force. It was just 2 days after that law came into force, but it had been widely foreshadowed and advertised for many months before that. When you were on your way back home, you were arrested by police at a railway station and found to be in possession of a knife. You have a high degree of culpability for the Dangerous Dogs Act offence. That is because you knew that the dog was prohibited and because there are no lower culpability factors. Your counsel made a submission that you could not reasonably have foreseen the incident. I acknowledge the care and responsibility with which that submission was advanced, but I do not agree with it. I am sure that you could and should have reasonably foreseen the risk. As well as knowing that the dog was prohibited, you knew that it had been pent up in the house for weeks. You knew that it was of a type that was capable of being aggressive, and you knew that Esther Martin could not control it. The incident was foreseeable, and indeed had been foreseen by those who had sought to warn you about the dogs. That is so, even though there had not been a previous similar incident with these dogs, and even though on other occasions the dogs had been well behaved, and even if the precise mechanism by which Esther Martin was attacked could not have been predicted. I accept that the dog was not trained to be aggressive, and so you do not have a high degree of culpability for that additional reason. I apply the Sentencing Council guideline for this offence, adopting the high culpability bracket. The starting point for sentence is 8 years custody, and the range is 6 to 14 years. Your previous convictions are a statutory aggravating feature, but I take into account that you have not previously been convicted of an offence relating to animals, and that your last convictions before February of 2024 were for offences committed in 2013. The fact that Esther Martin was not capable of controlling the dogs is not in itself an aggravating factor because it is inherent in the offence. But her physical immobility, her age, and her health meant not just that she could not hope to control the dogs, but also that she was unable to defend herself from them, and she was particularly vulnerable to injury. This was a sustained and repeated attack lasting at least 12 minutes and resulting in multiple injuries. You also put a child's life at risk, and you also potentially put at risk the lives of members of the public and emergency responders. That is because on at least one occasion, one of the adult dogs had escaped from your home, and also because anyone who attempted to break into the house to rescue Esther Martin would have been put at lethal risk. In addition, you had failed to respond to warnings and concerns about the dogs expressed by others, and you kept them in conditions which increased the risk that they would become aggressive. A number of these factors arise from your same general attitude and course of conduct. I've been careful not to double count them, but in aggregate they demonstrate a sustained pattern of disregard for the law and for the lives and safety of others. I treat them collectively as a substantial aggravating feature. As to mitigation, I have taken account of everything that has been put before me on your behalf in your counsel's careful mitigation. Once you were informed of what was happening, you did take some steps to try and arrange for a friend to intervene. You are the sole carer of a child in their early teens. Their mother very sadly died, and that child now faces the additional trauma of the incarceration of their father for a substantial period of time, and you face the enforced separation from your child. The principal reason why I asked for a pre-sentence report was to assess the impact on them of your incarceration. That report shows that adequate arrangements have been made for their care, but I do take into account as mitigation the impact that the separation will have on you and on them, and also the serious medical condition that afflicts the person who will have parental responsibility for them. I've had close regard to a letter written by the child to me. To the extent that you may have undiagnosed attention deficit hyperactivity disorder, as set out in the pre-sentence report, there is no evidence that has any impact on your culpability. I do not accept that you have shown any genuine remorse. You maintained not guilty pleas, thereby putting Esther Martin's family through the trauma of a contested trial, and you continue to maintain that you are not responsible for Esther Martin's death, claiming it was an unavoidable accident. That is not in law an aggravating feature, but you are not entitled to any reduction in sentence on account of remorse. The aggravating factors that I have outlined substantially outweigh the mitigation and require a substantial uplift from the category starting point. I will not impose separate penalties in respect of the offences of possession of a prohibited dog, because that is a feature that is relevant to you having a high culpability for this offence. I have therefore already taken it into account. In respect of the bladed article offence, the starting point is 6 months custody, and the range is 3 months to 1 year. The knife was carried on public transport for a considerable period of time, but it was kept in a bag and it was not brandished. Your previous convictions are an aggravating feature. The same mitigation applies, but in this case it outweighs that aggravating feature. I am sentencing you for 2 different offences of a different character and which are completely unrelated. It's appropriate to pass consecutive sentences. I make a reduction to the sentence I impose for the bladed article offence to ensure that the overall sentence passed is just and proportionate, and that it reflects your overall offending behaviour. Given the completely separate nature of the offending, only a modest reduction is appropriate. I make a disqualification order for life under Section 4 of the Dangerous Dogs Act 1991. That means you may not in the future have custody of a dog unless or until a court terminates this order. I impose a lifetime disqualification because your conduct demonstrates a sustained and deliberate disregard of the law, the exposure of others to serious and foreseeable risks, a failure properly to care for the dogs, and an absence, even now, of any real insight on your part as to your offending. That, together with the catastrophic consequences of your actions, shows a continuing and significant risk to the public if you ever again own or keep a dog. A lifetime disqualification is therefore necessary and proportionate for the protection of the public. I make a deprivation order in respect of the knife, and I impose the statutory surcharge in the sum of £228 or such other sum as is required by statute. In the light of such evidence as I have as to your means and the lengthy custodial sentence that I will impose, I do not make an order that you make any contribution towards the prosecution costs. Only a custodial sentence can be justified for these offences. As required by law, I will impose the shortest sentence that is commensurate with the seriousness of the offences. You will serve 40% of the sentence I impose in custody. After that, you will be released on licence. You must comply with the terms of the licence and commit no further offence, or else you will be liable to serve a further period in custody. Ashley Warren, please stand up. For the offence under the Dangerous Dogs Act, I sentence you to 10 years imprisonment. For the offence of being in possession of a bladed article, I impose a consecutive sentence of 3 months imprisonment. The overall sentence is therefore 10 years and 3 months.
Hi everyone. Hi. So today's sentencing brings a sense of relief and a long-awaited path towards peace for our family. While nothing can truly compensate for the loss of our mum, we are grateful that the court has recognised the gravity of this tragedy. The outcome represents the accountability we have fought for, and it sends a clear message that the lives of our loved ones are precious and that those responsible for such preventable heartbreaks will be held to the highest standard. To us, this sentence is more than just a number of years. It is a validation of the pain we have endured and a step towards protecting other families from the same nightmare.
We want to thank our families and friends for standing by us through our darkest chapter of our lives. We would also like to personally thank our family liaison officers for guiding us through this distressing and emotional time. Esther Martin, for anyone that knew her, knew she had a great laugh, a wicked sense of humour. She will be remembered for being a great friend to many, a sister, an aunt, a grandmother and a great-grandmother. But to us, she was and always will be our mum. Thank you very much.
Aspiring rapper Ashley Warren had left the dog with 68-year-old Esther Martin when she was killed in February 2024, just days after the XL Bully breed was banned in England and Wales. Sentencing Warren at Chelmsford Crown Court, Justice Johnson KC said he hadn't shown any remorse.
You had failed to respond to warnings and concerns about the dogs expressed by others, and you kept them in conditions which increased the risk that they would become aggressive. A number of these factors arise from your same general attitude and course of conduct. I've been careful not to double count them, but in aggregate they demonstrate a sustained pattern of disregard for the law and for the lives and safety of others.
Well, let's get the latest now from our correspondent down there, Phoebe Southworth. And Phoebe, the court heard how big these dogs were, one of them weighing more than 7 stone and the other 6 stone, and the fact that the Esther Martin had restricted movement and arthritis.
Yes, absolutely. The court heard that Esther Martin was a very slight woman. She was only just over 5 feet tall. She had mobility issues and other health problems, and she was essentially no match for the power and strength of these incredibly large and powerful animals. On the day of the attack, we know that Ashley Warren was in London. He was an aspiring rapper and he was filming a music video in London. And essentially, Esther Martin was left to take charge of these dogs on her own. There were 2 adult XL bullies and their litter of puppies, and we know that she was attacked by the 2 adults. In an attack that went on for about 12 minutes, it was sustained and it was brutal. She was bitten on nearly every part of her body and suffered from catastrophic injuries. The dogs were so aggressive that police had to use a taser to subdue them before they were able to get into the property to help her. We know that at the time it was an incredibly poignant attack, in the sense that only 2 days earlier there had been a ban in England and Wales on XL bully dogs. We know that Ashley Warren did not have a certificate of exemption, and he had made no attempt to get one at the time the attack was carried out. We did hear from Esther's daughters in court today. In their victim impact statements, they said that they will be forever haunted by the very violent way in which their mother died. And the judge said it was an entirely avoidable attack. And as you just heard there from the judge, Warren has showed no remorse for what happened.
Phoebe, thank you very much.